Hello, hello, hello. This is Attorney Mike Grevlin coming to you from Chicago. As usual, we got some good stuff for you. I have to thank Nora HC for in Discord for sending me the drunk guy who rolls into 3B to get sentenced. That's good. We got a guy asserting the wrong pants defense, and we've got our old friend Judge Gauthier up in northern Michigan, all filled with disappointment. And when you see, you'll understand why. Let's do it, shall we?
Come on.
Nope, you're done. You don't even have to come in, okay?
Well, amen. I love you.
Thank you. You have a good day.
Man, we tried to give you every opportunity to make a better life, and all you have done is lie, cheat, and steal.
Eddie Gibbs.
This guy
Yes, ma'am.
is a
Hi, Mr. Gibbs. How are you today?
Hi. Hi, Judge.
How are you today?
I'm blessed and highly favored, ma'am.
Well, isn't that wonderful? So here's the deal. You've got this one possession of drug paraphernalia from
he asserts a terrible, terrible defense, but he is so darn likable.
July 8th. How do you want to handle that?
If I may,
You what?
it wasn't my doggone pants.
What?
They weren't my pants, so I don't even do drugs. What it was is that I got caught doing, I preached the word, and somebody had got my bike. And I went over there by McDonald's to go get my bike. My pants, they're all dirty. So I had to wear my roommate's pants. So I had my belt on, so I didn't check. I'm going to go get my bicycle. And they gave me
So you put your roommate's pants on,
Yeah.
and your roommate's pants had stuff in the pockets.
Yes, I didn't check.
But so who was in control of that situation at that time?
I was, because I had to.
I know. I'm so sorry,
Yeah.
Mr.
Okay, Judge, I controlled the pants scenario.
Gibbs.
I understand. It's so fine. It's all
But
right.
you can plead not guilty, no contest, or guilty. You're welcome
I'm
to
guilty
plead.
because I had them on. So.
I know. Well, but you can come in, if you want to come in and talk to the prosecutor to see if you can work out a different deal. If you are concerned about the conviction,
Nah.
you're not concerned about that?
Nah.
Well, I was done. I had the pants on, even the bet was tight. But I had the pants on. So I'm accept whatever the consequences are, ma'am. And
But the consequences could be something that Mr. Gibbs, if this conviction, if a possession drug paraphernalia conviction is going to hurt you, some people go, I've had all these other convictions, it doesn't matter.
yes, ma'am.
But if you are saying, that might affect your ability, because didn't you tell me you're a preacher?
Well, I am trying to preach the word.
Okay.
It's called Divine Fellowship of Love.
Okay.
I'm trying to preach the word. It's so good.
Well, I don't want to do anything that's going to negatively affect your ability to do what you want to do that way.
Yes, ma'am.
So if you want to come in and talk to the prosecutor, you're welcome to do that and see if she'll, if she, maybe she would offer you deferred. You'd have to pay some money up front, probably.
No, ma'am, Miss Plant, all I want to do is get it over with. Like I say, they wasn't my pants, so what? I accept what it is, and I'm ready to.
They wasn't my pants, so what? So many t-shirts.
Just move on and get my life right. My life is right. I'm doing God's work. So I'm all right. So I accept what I have to do.
So I guess from in my mind and in your mind, God knows. God knows.
He knows.
So,
he knows. Yes, ma'am.
Okay. So are you pleading guilty or no contest?
I'm pleading guilty, or get it on there with and get them back out there and try to get my bear and everything and get back to work. Whatever it is, I'm pleading it.
Oh yeah, he needs to get back to work. That's the prime concern here. I love it.
No contest. I don't understand what no content was, but
It doesn't have any different impact in this situation than guilty does. You can plead no contest where you go, well, I'm not really admitting I'm guilty. I'm just saying that you can use this plea of no contest against me. It's a legal term of art. It's really more applicable to like car accidents and things, but
yes,
you can certainly plead no contest but I'll still find you guilty.
I plead guilty.
Okay. Okay,
Yes,
I'm going to
ma'am.
find you guilty, and I'm actually going to time serve you on this. So,
Yes,
Maria, I'm actually adjusting the fine to $219.
Okay.
Okay, Mr. Gibbs, I'm going to give you the benefit of the doubt on that. I am going to adjust your fine to $219. Your court costs are $81. Your total's $300, and you are time served. Okay?
Yes, ma'am. And I'll be there at 2:00 today, tomorrow.
Nope, you're done. You don't even have to come in. Okay?
Well, amen. I love you.
Thank you. You have a good day.
You too, ma'am. Thank
Thank
you.
you, Mr. Gibbs. Mr. Brown,
Yes, Your Honor.
on July 8th, you received a citation for no driver's license. Do you want to plead not guilty, no contest, or guilty?
Guilty, ma'am.
Mr. Brown, your time served. You're also free to go.
Yes, ma'am. Thank you.
Uh-huh. Brandon Britton. Mr. Britton, you have a theft citation for May 17th of 2023. You pled not guilty on June 16th of 2023. Then you had a public intoxication from that day, pled not guilty. It looks like you failed to come back on your jail release. How do you want to handle those today? You want to maintain your pleas of not guilty or change your plea to guilty or no contest?
Is there a way that I can get out today and come back tomorrow? Or?
That question is, that's the second question. The first question is, do you want to maintain your plea of guilty or not guilty, or do you want to change your plea to guilty or no contest?
Well, I'm going to maintain my plea of not guilty.
Okay, then you'll have to post a surety or cash bond. So you need to contact a bondsman. Okay?
All right. You didn't you seem like you were more clear with everyone else than you were with me. It was like, mine was like a riddle. If I say this, you'll say this. I'm more, like if I say guilty, how much till I get it over with?
Let me take a look because you had some previous jail time. Give me a moment.
I'll go ahead and get it over with.
Give me a moment, please. And I'll tell you, because I want to tell you your jail time so that we are clear. Okay, on the theft from May 17th of 2023, sir, if you changed your plea to guilty or no contest, you would be time served. On the public intoxication, sir, if you changed your plea, you would receive $450 jail credit. Your balance would be $84.
Change my plea to guilty.
On both?
Yeah.
Okay. So on the theft charge, based on your plea of guilty, sir, I will find you guilty. I'll assess a $585 fine and court cost. I will time serve you. Mr. Britton, on the public intoxication from June 16th of 2023, based on your plea of guilty, I will find you guilty. I'll assess a $534 fine and court cost, give you 3 days jail credit. And I will release you on that one to appear here at municipal court no later than 2 p.m. on the first business day following your release. Your balance will be $84. Okay?
All I owe is $80, so I need to bring $84.
You either need to just show up at 2 o'clock and we'll set up a payment arrangement with you. But if you have the $84 and want to pay it and not come into court and see me, you're welcome to pay that before 2 o'clock tomorrow.
I can bring anything, $20.
Yeah.
All right.
But you can bring the whole 84 and not come into the courtroom. If you say you can't afford to pay $84 tomorrow, You just make sure you show up and we'll set up a payment plan with you, okay?
I'm bringing something.
Okay, we'll see you tomorrow.
So I'm being released as of now.
Yeah, we're finished with you. I don't know if you have any other charges, but the city's finished. The deputy's going to give you a map of directions to our court. Good luck.
This is file 23137 SD, People versus Norbert Herbert.
Excuse me, sir.
Oops, yeah, thanks. Thank you. Yep. Start again. Take a deep breath. This is file number 23137 SD, People versus Norbert Herbert Schroeder. Mr. Schroeder is here with his attorney, Mr. Paul Gibson. He's charged with operating while intoxicated. First offense. Matter is set for sentencing this morning. Mr. Matthew Huff is here from the probation department. He had prepared the screening report. He did just give me a discharge treatment summary report from the Michiana Behavioral Health Center in Plymouth. And Mr. Gibson, what would you like me to know?
Well, the defendant, he still has a case in Indiana for OWI that he tells me is unresolved.
I know his client has made this difficult, but this is the this is the worst pre-sentence argument I've ever heard. You'll see.
When you look at Mr. Schroeder's history, he does have, as Matt says, this looks like it's his 6th drunk driving offense, but the defendant would like the court to know that he did abstain from, it looks like he was able to go about 10 years without getting pulled over for an OWI. And so he does have a bad history, but this is over a period of over 20.
My client has six DWIs. He does have a bad history. Like, I get it. He's trying to minimize it. All that, he eats all that to get out. You know, there was close to a decade gap in there where he didn't have one. And you know he was doing it. He just didn't get caught for some reason.
Years. And so the defendant is asking for a chance to prove himself. He would ask for something as an alternative to jail time, whether it be probation, community service, but he's asking for leniency here, and I'm sure he has things to add. Thank you.
All right, Mr. Schroeder, what would you like me to know?
Well, a lot of these charges were back when I was in my early 20s, and I abstained from drinking. And just recently here, when I got this one and one in Indiana.
Of course, he fails to mention that he's currently drunk.
Going through a divorce. And, that kind of hit me real hard after the holidays. So. But, I know that's not really an excuse, but it hit me hard.
Yes. It used to be, for it to be a felony offense, you had to have 3 drunk drivings within 10 years, and that's what it is, and then it became 3 in a lifetime. You had to have 2 and 7 or 3 and 10. And now it's 2 and 7 or 3 in a lifetime. So you had 1, 2, 3, 4 in the 2000s. And then in 2014, you got another drunk driving in Knox City, Indiana.
Yes.
And then after that, there was a meth charge that you had some struggle with.
Well,
So this is 1, 2, 3, 4, 5. This is your 6th offense, but the most recent one was 2014. The prosecutor charged it as a first offense. You had a very high blood alcohol level. You were driving very badly. You crashed into a mailbox. They did do a blood draw. And
That mailbox jumped right in front of him, Judge.
then a few days later, you got arrested again. My suspicion is Indiana is really going to
Yeah,
take
they're
some.
gonna nail me.
I think they are. All right, but it is nonetheless a sixth offense. Then you didn't show up for your screening. Matt modified things a little bit after you did show up. He got another day credit for fail to appear. So
Depending on how you want to count that, I believe it was in the ROA as contempt of court. I don't know
Yes.
if you count that towards your credit
I
on the
would.
sentence. Okay.
I don't have to. I guess you're right. I don't really want you on probation. You got a charge pending in Indiana. I'm going to give you 45 days credit too, leaving 43 days to serve. There will be some good time calculated in that. You will get out and then you can deal with your Indiana case.
Okay, my court date there is August 30th.
You'll be done with this by August 30th.
Okay.
There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee. I'll cut the screening fee in half. The attorney fee is $150. Was there a police reimbursement for the blood draw?
It was not submitted in the police report that I obtained from the prosecutor's office.
All right, we'll just leave it out. 300 plus 75 plus 50 plus 50 plus 150 is 625. I don't believe I have any bond money. All right, you're gonna have to deal with your Indiana stuff, but you're a danger to the people here.
Yep.
Saying that you had a rough Christmas, then don't drive a car.
I know, that was
All right,
definitely enough.
all right, you go with officers. Let me
But wait.
give you this envelope. I'll give it to your friend here.
There's
I'm
more.
gonna make that 625.
No,
By September 30th.
Keep my phone anyway there.
Thank you, sir. That lady.
Here we go. Recall.
168.
Paul's here.
I figured it'd be more than a name.
All right. Hey, booking. Could you guys put Norbert Schroeder in the Polycom room? Yes, thanks. Bye. Paul, Mr. Schroeder was a .168. I can't sentence him when he's twice the legal limit, so we're going to have to reschedule his sentence. So I'm going to have him brought into the Polycom room. We'll address it.
Okay, I guess Mr. Wood, I don't know if he's going to be here or not.
He's probably not. So as soon as we finish with Mr. Schroeder, we will call Mr. Wood's case, then I'll let you go. He didn't say much, but he's an experienced drinker, I think, and
Oh, yeah, he is.
Jenny, can I have the Norbert Schroeder case back, please?
It looks like Thursday I'll be here.
What time?
The afternoon, like 1 or 2 o'clock.
That'll probably work fine. We'll set it for 2 o'clock Thursday afternoon. Mr. Schroeder, I ask that you come back to the jail, back for Polycom. Your lawyer, Mr. Gibson, is still here. We just did a sentencing in People versus Norbert Herbert Schroeder. The bailiff indicated that he felt you had been drinking. They gave you a preliminary breath test at the jail and the result was 0.168. So I can't sentence you while you're intoxicated.
I give the judge credit. I mean, he didn't appear intoxicated during the hearing. Like he said, he didn't say much, but I wouldn't have known unless somebody knew. But of course, the bailiff, they're closer, so they have a better sense.
So I find that you're in contempt. Another 5 days jail. I'm going to reset sentence for July 13th at 2 p.m.
12-hour shifts in that.
I could have let it stand, but by the fact that you're intoxicated, takes away the fact that this was a knowing and voluntary and understanding proceeding.
Yep, that's
But I
the
find
problem.
that you're in contempt for coming to court while intoxicated. And we will address this further Thursday at 2 o'clock. You can go get some lunch.
Go get
Can
some
I
rest.
ask you a question?
Jail lunch.
Yes, Judge.
Why would you do this?
My apologies, Your Honor. May I speak with Ms. Frank just briefly?
Okay.
Sure.
Warning. This is
Mr.
ultimately
Vogler, you
depressing.
ready with Ms. Flynn?
Yep.
Okay, so this is from page 3, People versus Brittany Flynn. Three files, 93255, 93256, and 93257. And we're here for a docket call in all three files. Mr. Vogler, do you know how we're proceeding?
Your Honor, yes, there's been a plea agreement reached. Ms. Flynn will plead guilty to the charge in file 93255. That's larceny in a building. The other files would be dismissed. That's a correct statement.
Okay. All right, Ms. Flynn, would you please, as best you can, raise your right hand for me? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, put your hand down. Are you Brittany Nicole Flynn? Yes. Ms. Flynn, a guilty plea hearing is important because you waive a lot of rights. So I want you to listen carefully. At any time, if you have a question, ask it. If you need more time to talk to the prosecutor, or I'm sorry, to talk to your attorney, go ahead and just ask me, okay? Now I have to advise you the maximum penalty that you could face. Larceny in the building is a felony crime with a maximum penalty of 4 years in prison and or a $5,000 fine. Do you understand the maximum penalty you could face? Are you on probation or parole?
I'm probation here.
Okay. To district court or?
District.
Okay, in Crystal County?
I get sentenced tomorrow.
Okay. Okay. Did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
You understand that this lists several of the rights that you have that you give up when you enter a plea?
Yes, Your Honor.
And is that what you wish to do?
Yes, sir.
If I accept your plea, you can't come back later and tell me that somebody threatened you or promised you things outside the plea agreement or for some other reason it wasn't your own choice. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. If you want to appeal, you have to get permission by filing an application.
Yes,
And
sir.
the types of issues you could raise are much more limited than if you went to trial. Do you understand that?
Yes, sir.
All right, the plea agreement stated on the record is that in exchange for your plea in this file, the other two files will be dismissed. Do you understand that?
Yes, sir.
Mr. Vogler's had a full, fair, and accurate statement of the terms of the agreement.
Yes.
Mr. Ratzman?
Yes, it is, Judge.
Ms. Flynn, other than that agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you?
No.
Is it your own free choice to plead guilty?
Yes, sir.
Knowing all this, how do you wish to plead to the charge of larceny in building?
Guilty, Your Honor.
So on or about February 15th of this year, were you in the Posen Fire Hall in Prescott County?
Yes, sir.
While you were inside that building, did you take $40 in cash?
Yes, sir.
Did it belong to you?
No, sir.
You took that without permission?
Yes, sir.
And that was for the intent for you to use it for your own purposes?
Yes, sir.
Mr. Vogler, are you satisfied with that factual basis?
Yes.
Mr. Radsman?
Yes, I am, Judge.
Mr. Vogler, are you aware of any other promises, threats, or inducements?
No.
Mr. Radsman?
No, I'm not.
And Mr. Vogler, do you believe I comply with MCR 6.302?
I believe the court has.
Mr. Radsman? Have I complied with the court rules?
Yes, you have.
All right, Mr. Flynn, I find that your plea is knowingly, understandingly, and voluntarily made, that there is a sufficient basis in fact and law to believe you're guilty of that crime. So I'll accept your plea. We'll schedule sentencing for August 7th at 9:40 a.m. here in the courtroom.
I do have a request, for bond, you know.
Okay, go ahead.
So originally, the bond in this case was $5,000 cash or surety. That was posted, and then she ran into with other charges that just got dismissed. She is scheduled tomorrow to be sentenced on a probation violation and a couple of contempt of courts. The contempt of courts are bond violations, and those bond violations are all the alleged criminal offenses. The probation violation, which she's pled to, and she's, like I said, going to be sentenced tomorrow, that is a 1-year misdemeanor, so it's, she could get a whole year, which she would have at least credit going back to March 7th. That's how long she's been. She resides in Alpena. She has 2 young children, very young children, actually, and even taken care of by her mother and her parents. So this time, given the length of time she stayed, given this offense, I would ask for a personal recognizance bond. She would sign that, it was released and until we find out what the sentence is tomorrow.
Mr. Radsman, in your position.
Yes, Judge, the people would object. Your Honor, the underlying offense that she pled guilty to occurred while she was on a work crew detail for district court, arising out of an offense at district court, and involved her taking funds from one of the co-work crew people. This offense occurred while she was under the district court jurisdiction, and quite frankly, under some kind of district court probation. She was on work group. So I don't think his personal attack.
Okay, that'd be a no.
Judge Barton tomorrow.
How long has she been in custody on this?
I think she's been there since March 7th. She was arrested, she bonded out, and then, and I can't recall, I asked for it to be canceled, and how she did, because she had already posted when the other charges came home.
I mean, on the one hand, I certainly share what I sense to be the outrage from the prosecutor that somebody, while they're on probation, while they're doing community service under the sheriff's detail and court supervision, is committing a felony crime that really undermines a program that helps people not be in jail. So even though this is an intermediate sanction sentencing, I'm sure, those facts would cause me to certainly give some jail for that. But man, she's already served about 4 months on what's going to be an F grid, probably a 0 to 6 month guidelines, I'm guessing. I don't know. But violated probation and having a sentencing for that tomorrow, I'll go ahead and we'll be back for sentencing August 7th.
Thank you. Thank you.
So we can call People versus Haley Frank. This is file 21-93179FH. And here for probation violation sentencing. Have you had a chance to review the probation violation report, Mr. Gilbert?
Yes, Your Honor, and I have gone through it with Ms. Frank.
All right. And any additions or corrections?
There are not, thank you.
Would you say?
Yes, Your Honor, I guess currently Ms. Frank has been sentenced to 93 days from district court from the underlying offense that created this violation. She did plead guilty, and she is serving the time for that in district court. And I believe she gets out August 21st. And I believe the math comes out that it's probably pretty much the same thing. But I would ask the court to consider time served in this matter because she will be serving yet a month and a half to go. Thank you.
Ms. Frank, it's not required that you would say anything today, but it is allowed. Is there anything you wish to say? You don't have to, but you can tell me anything you want.
I'm just really sorry, Your Honor. No. To take that into consideration, what Mr. Gilbert said.
Mr. Radsma?
Your Honor, please support the recommendation.
Ms. Frank, we sentenced you a while back on a charge of attempted larceny in a building. For stealing from your workplace. We put you in the Swift Insure program, and you provided false documentation to your supervising agent and lied in court about your progress. You know, you were removed from the program but continued on your probation. Then while you're on your probation, trying to get a job, and then you're at work, you're stealing from a workplace again. I don't know, Ms. Frank, I mean, we gave you a chance, and we gave you an honest chance. We were all rooting for you. We were all trying to connect you with services. You've had some bad things that have happened in your life. Some are not your fault. Some have been brought on by yourself. But man, we tried to give you every opportunity to make a better life, and all you have done is lie, cheat, and steal. And while you're on felony probation for stealing from an employer, you steal from an employer. When we sentenced you originally, the guidelines were 0 to 6 months. When, when there's violations like this, and by the way, you caught a break. When you provided that false documentation, you could have been charged with felony, obstruction of justice, tampering with evidence. That's evidence to be presented as part of your probation in court. People need to understand that. You're better off just fessing up to what you violated. If you present something false, you could be charged with a felony for that. You weren't. So you still got a lot of chances, a lot of breaks. I could go above those guidelines based on all this. I'm not going to do that. It is very tough for me to see why I shouldn't give the top end of that guideline. So that's what I'm going to do. I'm revoking your probation. You're going to serve 6 months in the Presbyterian jail. Credit to the 60 days in the report. All right. Good luck, Ms. Frank.
The wheels of justice are going to roll you right into the Wayne County Jail.
Well, there you have it. That was a fun smattering of clips. Okay, Judge Gothier stuff wasn't very fun, but it was interesting. Poor guy. He's just so disappointed. You can see it's sincere. He's really pulling for him, and they steal while they're on probation for stealing. What can you do with that? But smack him with the sentence. Oh, good Lord. You know, she might have been better off instead of doing that, just trying the wrong pants defense. It couldn't have been worse. Wrong pants defense guy, to his credit, he owned it though. He's like, okay, fine. I was the one who chose to put the wrong pants on. I don't believe the wrong pants defense in the first place, but you know, either way, we got there. It was a guilty plea. He was fun. I do like Judge Hamilton. She's just, I don't know. That's just a vibe over there. I like to visit that. Not much has to happen for me to show that. I don't know why. I just like that call. All right. Thank you all for coming out. I will see you all soon.